Just first of all, want to welcome all of our audience members. We appreciate you joining us for today's presentation on international abductions and the Hague Convention. We also want to thank all of our panelists today. Russell is joined today by family lawyers Fareen, Jamal, and Fadwa Yehia of Jamal Family Law Professional Law Corporation, as well as Bryan R.G. Smith and Lindsey Love Forrester of Lerners LLP. In the next 1 hour, you can expect our speakers to cover the following topics. Top 10 things you should know about the Hague Convention. What are non-Hague cases and how are they different? And they'll also be doing a case study on the following cases: FVN and Lee versus Rubio. The panelists will also be taking audience questions throughout the presentation, and will also reserve a few moments at the end of the presentation for Q&A as well. And as always, this presentation is not intended to provide legal advice, but rather to provide general information on these topics. And we please ask that you keep that in mind as you listen and submit your questions. So without further ado, it's now my pleasure to introduce today's hosts. First of all, we have Fareen Jamal, who practices family law and estate litigation at Jamal Family Law Professional Corporation in Oakville, Ontario. Fareen serves as a deputy judge in Milton, Brampton, and Burlington, and is also an accredited mediator. She is a panel member on the Office of the Children's Lawyer, Personal Rights Panel, and Fareen has also served as the chair on the Ontario Bar Association's Family Law section, and was a board member of the Ismaili Conciliation and Arbitration Board. Fareen completed her master's in law, specializing in family law in 2012, and was the 2014 recipient for the OBA Young Lawyers Award. Bryan is a member of the Family Law Rules Committee and a member of Superior Court of Justice Family Working Group, appointed the family judge for Ontario, Suzanne Stevenson, and is a co-chair of the 6-Minute Family Law Lawyer. Next, we have Fadwa Yehia, who is an associate at Jamal Family Law, where she practices in all areas of family law with a special focus on child-related matters, including cases involving parent-child contact problems, jurisdictional and mobility disputes, as well as international abduction. She has represented clients at all levels of court, including the Ontario Court of Appeal and the Supreme Court of Canada. Fadwa Advocate Society, the Association, and the Arab Canadian Lawyers Association. She served as the vice president of the board of directors to the United Nations Association in Canada, Toronto Region branch for several years. She was also recently appointed to the board of directors for the Association of Family and Conciliation Courts, Ontario chapter. Next, we have Lindsey Love Forrester, who's a family lawyer and partner at Lerners LLP. She was called to the bar in 2009 after earning her Juris Doctor and Certificate in International Business Law at Queen's University. With over 10 years of family law experience, Lindsey has been involved in several noteworthy cases and has served as co-chair of multiple family law programs at the Ontario Bar Association. Next, we have Bryan R.G. Smith, who is a partner at Lerners LLP. His practice is restricted to family law and has also completed the Ministry of the Attorney General training to conduct mediations and arbitrations. During his 30+ years of experience, Bryan has received several recognitions, such as leading practitioner by Chambers High Net Worth Guide in the area of family and matrimonial law, distinguished lawyer rating from Martindale-Hubbell Canada, and as a leading family lawyer with Lexpert. Last but not least, we have Russell Alexander, and Russell is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. With nearly 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them in coping with the difficulties of separation and divorce, the division of assets such as homes and pensions, and the calculation and enforcement of child and spousal support. He uses his experience to create unique solutions for each of his clients to enable them and their families to move forward, and supports them through the transition of divorce and separation. And now it's my pleasure to pass things over to Russell to get started with the presentation.
Well, thank you to our audience members. We've got about 350 registered in our esteemed panelists. Shannon, great introductions. So let's see who our audience is today and see our poll results of our first poll. 72% lawyers practicing. Well, you're in the right spot if you want to learn about the subject matter. Other professionals, 14%, professional in another field. We've got 8 students joining us today. Welcome. It's great to have students join us. One trying to navigate a family law matter, one helping another, and another who's going to tell us anonymously. So thank you for participating. We're going to do one more quick poll, and then we're going to make a start. We have about 1 hour of material. one day of material to fit into 1 hour. So the first part is going to be a little bit quicker, and then we're going to slow down for the analysis and the feedback from the counsel we have who argued the case before the Supreme Court of Canada. So our second poll question: have you ever argued an international return case before? And we had a chit chat yesterday when we're preparing for today. One of our possible poll questions was on the cost of these cases. And maybe I'll start off with Bryan. What do you think? 300-400 grand for a case that goes all the way to the Supreme Court, or even an international child abduction case? What should people be looking at in terms of legal fees?
If it were that, I think they would have had a bargain. They're very, very expensive, especially to go all the way to the Supreme Court. You're looking at a trial, an appeal, and an appeal from the appeal, not to mention conferences, questionings, etc. They're very expensive cases to prosecute.
Right. All right. Let's see our poll. Thank you, Bryan. Let's see our poll results. Yes, surprisingly, 15%, 23 counsel have argued these cases. Majority, 78% no, and 7% referred to other counsel, which would probably be what I would do definitely after speaking with our panelists today. So let's make a start. We've got 10 things you should know about the Hague Convention. We're going to kind of fly through this quickly and spend a little bit more time on tips and tricks, and then we're going to get into our case studies. So Bryan or Lindsey, do you want to tell us, first of all, what is it?
The Hague Convention is an international treaty that is intended to provide for expeditious resolution of what I call international kidnapping cases, where a parent has removed a child from the place of their habitual residence and taken them elsewhere. It is part of the law of Ontario and is codified in Section 46 of the Children's Law Reform Act. So if you actually want to read it, for those of you who aren't familiar with the legislation, you can go to the Children's Law Reform Act either through CanLII or e-laws, and it's completely set out there. There are basically two aspects to it. The starting, but certainly not final point of it is to read the Supreme Court of Canada decision in bailiff, and then to figure out how it's been applied after. The first part of it involves determining where the child is habitually resident. One would have thought that was an easy task to do. Bailiff set out a test which trial judges and appellate courts have had difficulty following since that was promulgated in 2018. The other part that applies under most of these cases is a reliance on Section 13, which is the defense of not returning a child to a place where there's an intolerable situation that may arise. Those are really the two issues under a Hague case. And while the convention was initially established to allow for prompt return, in practice, these things are not that prompt. They take a long time to work their way through the courts. They're factually complex cases, and they are very difficult for judges and appellate courts to deal with.
Thank you. All right, so next question, what forms do you use? Fareen or Fadwa?
So it's actually the same set of forms that we use in an ordinary course, but there is actually two parallel processes that could exist. Every signatory to the Hague Convention and every state, so every province, has what's called a central authority. And the central authority in each contracting state receives applications for the return of children and even for access to children. And they try to attempt to secure the voluntary return of the child, to provide general information about the child and state laws. So if you're looking for information about state laws of a country, a central authority is actually a bank for that. And they're to initiate necessary proceedings for the return of a child and help secure legal aid for parties. They also make administrative arrangements to secure the safe return of children. So if that's required, you can count on them for that. So in Ontario, the central authority, the fellow, his name is Shane Fools. He's actually at FRO as well. He's fantastic. So if you have any one of these, reach out to Shane. He's really lovely. He helps you with all the application information. He lets the courts closest to the children know that these children, that there's been an application for that these children have been wrongfully removed or wrongfully retained. Remember that the Hague Convention is just to move children to the country where the children were habitually resident for that country to make the determination on custody and access. The country left behind isn't the one that's doing that. It's like a preliminary measure to have it heard in the country where it's to happen. So that's what forms do they use? The Hague Convention has been I'm kind of answering this in the next question together, but the Hague Convention.
Let's go to our next slide and we'll get to it. So the forms are the forms where the child is resident at the time is apprehended, right?
Yeah,
so
there
the
are
child's brought to Ontario from a different country, you use the Ontario forms.
So I was just going to say the Hague Convention is incorporated into provincial legislation, into provincial statutes. So in Ontario, that's the Children's Law Reform Act. Now, the application process through the central authority, there is actually an application form to sort of put them on notice and for the central authority to be aware of the situation. There is a set of applications. There isn't a separate set of rules or codes or regulations. There is, Shane is fabulous at walking you through that process in terms of alerting the courts about the fact that don't make a custody access order about these children until this issue has been determined, until habitual residence is determined and this aspect of it is dealt with. And then the process is intended to be a summary process. In Quebec, they allow a full hearing with viva voce evidence, and it's a request to the Chief Justice. That's their ordinary course. But the convention contains its own codes and rules for the expeditious enforcement of custody rights. It's not intended to be the forum for the determination of the custody merits. In Ontario, in our case, we had a full hearing, but often in many of the jurisdictions, it's heard through affidavit evidence, with exhibits, and that tends to be the usual practice in many jurisdictions. So be aware of that in terms of process.
And so if the child's here in Ontario, right?
Yes.
In terms of deadlines, is it the Ontario rules and the deadline set it in the Ontario rules that would apply?
Yeah, so very recently, and I'm part of the rules committee, there was a change to the rules to try to think about deadlines. So when I think about deadlines, really the first one that comes to mind is 1 year, right? If the child has been in the country for 1 year, well, then you have a much harder time with applying the Hague Convention. But the other now that these rules have been updated, and they were just updated very recently, I want to say February of this year, but it's incredibly recently. And it's now Rule 37.2, where they're trying to make these cases be heard as expeditiously as possible. So the first thing is the courthouse must alert the OCL each time there's one of these cases, and they're now being put on a separate list that's being case managed differently. So with the prompt decision, prompt disposition, they now require international child abduction cases to be disposed of not later than 6 weeks after the case is commenced. And there has to be a hearing within 7 days after the case is commenced, a first meeting with the parties and the judge. And then they want a judge assigned to it as to case manage it and monitor its progress as soon as possible. And that includes setting a timetable for materials, a hearing date. We had one in our case. Justice Kerr's case managed it excellently well. And that was even before the rule change. Milton Court was fairly good at, being prescient on how some of this should be dealt with.
And then we have 37.2 coming up as a couple slides, but just before we get there, do we commence this proceeding in Canada, Bryan or Lindsey, or where's the initial commencement?
So the quick answer is the proceeding is commenced where the child has been taken to or removed from. So it's usually the applicant in a convention application is the left behind parent, but it could be another person, an aunt or a child welfare agency. And Fareen spoke to the central authority, and specifically in Ontario with Shane Fold. They have a role in these proceedings, like helping understand the process or liaising with police if the issues you're actually trying to find a child. But with the exception of, I think, New Brunswick, it's the applicant parent or whoever's bringing the proceeding actually has to retain counsel and file the application in the court. So, or they can do it on their own, and that will be filed in the jurisdiction, like I said, where the child has been removed to. So if a parent abducts a child that's habitually resident in Texas to Ontario, to Toronto, then the application will be filed in the Toronto court.
We have lots of questions coming in. What if it's not a signatory to the Hague, the country? We're going to talk about that as part of our analysis today, but these are sort of the practical questions we're trying to get through initially. So Fareen or Fadwa, how do you affect, I'm just thinking, how do you affect service of these
Sure.
documents? Now that you got the right form, how do you get it served?
Yeah, so just let me add on to Lindsey's question about where you commence the proceedings. Sometimes we commence even though let's say they've gone from Canada to Florida. Sometimes we commence the court order here also, and we get what's called a chasing order. And that helps in establishing the custody rights in the first place. And so you can also get chasing orders. Those are also sort of advisable and a good way to start. But in terms of service, so once you've got that, that helps too. But there is a Hague Service Convention. It's a way for international service of documents. You have to check whether the country that there's 79 countries that are signatories. So you have to check whether the other country is a signatory. There's a website, HCCH, it's the Hague Convention website. It's excellent in terms of process, whether documents need to be translated. So it's really good in terms of telling you where the countries are. When you're serving documents abroad, you have to comply with the Service Abroad Hague Convention. It's a 1965 convention. The case of Wang and Lin, the divisional court, really sort of walks through what's required and the consequences of not following it. The government of Alberta has prepared a reference document that sort of summarizes some of the service requirements and translation requirements. That's really the crappiest part, is you have to translate all of your documents, and that can be quite expensive. But each state has practical information sheets. It has to be served on the central authority of the receiving state. As lawyers called to the Law Society, we can send the information to the central authority, but otherwise the Attorney General, other central authorities can send that information. So we can send it directly to the receiving central authority, who then is responsible for serving it. And when you do that, you have to give them 2 copies of your issued documents, blank responding documents. You need to give them, send the central authority, there's a warning, a certificate, there's a request for service for judicial or extrajudicial documents. All of that can be found on the website. And then you also need to send payment in their required currency before sending the documents. Confirm through their practical information sheet their exact fee and how they're going to accept payment. The central authority in Ontario charges you $99. And so if you want to send it through the central authority, that's another option. So that's how to effect service if they are signatories to the service convention.
It sounds like pre-pandemic, when we had all the paper and we'd send the blank financial statement with the application and everything else. Okay, so Bryan or Lindsey, we now got the forms, we've figured out the rules, we've effected service. Where do you conduct the hearing?
Okay, so similar to where you started the application, the hearing is conducted in the jurisdiction where the application is brought. So my earlier example of a child being wrongfully removed from Texas to Toronto, the hearing itself would actually be heard in Toronto. And currently Hague applications in the Toronto region are being heard in person. So make sure to check your provincial and regional practice directions, just in terms of what is or isn't being heard, and some specify for Hague applications. Article 2, the convention requires signatories to employ the most expeditious procedures available. And in Hague applications, like Fareen mentioned, oral evidence is the exception rather than the rule. So prior to COVID, video conferencing was facilitated for witnesses or parties who were in the foreign jurisdiction and where it wasn't feasible or practical for them to come to Toronto for a hearing. Obviously, COVID has changed those things, and our matter was not a Hague matter. It was the trial itself was entirely virtual, and we had witnesses in from Dubai and from all over.
Thank you. All right, so next question. Now you've had your hearing, you've got your order. Fareen or Fadwa, how do you enforce it, right? It's hard to enforce orders in your own jurisdiction, let alone a different country.
Yeah, and that's why when Lindsey was saying you're starting the country where the children are, that's really part of the reason that you do that, so that they can enforce the order where the children are. But if you got a chasing order, let's say you got the chasing order here and they're in Florida, there are actually lots of mechanisms that you can use. At the end of the day, the quickest, like, you're going to need counsel at the other place, at the other country, the foreign jurisdiction, to enforce the order. But there are several things you can do here. You can mandate as a condition or as an undertaking a mirror order in the other jurisdiction. So you have mirror orders in both jurisdictions. And the majority, like, when I forgot to go through the statistics, but a lot of our abductions are from the United States. And so when we were doing mirror orders, there's things like, because they don't have OHIP or, standardized healthcare, government funded healthcare, things like that are where your mirror orders come apart, because those are required terms for them. And, so think through some of those things as you're doing these mirror orders. There's an excellent resource that we have all across Canada. It's called interjudicial conference calls. You can ask for an interjudicial conference call. You send a letter to Justice Stevenson, and there are 2 judges in all of Canada who manage it, Justice O'Connell for the rest of Canada and Justice Chamberlain for Quebec. And so it used to be Justice Robin Diamond, and she was incredible at it because she had built all these relationships with Indian judges and Pakistani judges. So countries that ordinarily you'd have a really hard time getting mirror orders or enforcement. So if you have an interjudicial conference call, you've got the ear of a judge in another country who's committing to a judge in this country about enforcement. So that's a really helpful tool. I find it an under-resourced tool. So think about, using the interjudicial conference calls more if you have these international cases.
It's really interesting. I've actually had a case where a child was taken to Alberta, jurisdiction was Ontario, and I think it was Justice Ingram called up the judge in Alberta who made the order in Alberta and had a call saying, what's happening here, right? Just try to get things sorted. But that's interesting that's available. Let's go to our audience because we want to get our audience feedback, and we're firing a lot of information off quickly on purpose because we want to save some time for later. So should the court consider fresh evidence at the appellant level? And one of the people who clicked other as our audience is a judge in Florida who signed on to learn more about this. So welcome. It's great to have you join us today. And let's see what our audience thinks of this result. So should the court consider fresh evidence? 71% said yes. 29% said no. Interesting result. One more quick poll question for our audience, and then we're going to get into appeals. Should they allow new evidence, which is different than fresh evidence, at the appeal level? So we'll give that a few minutes for everybody to answer. I got a question that came in from our audience, and I think I'm going to send this back to Bryan. We're talking about the fees, and we talked about this yesterday when we're preparing. $300,000, $400,000, $500,000. How are people funding these cases?
Unfortunately, it's like many other family law cases. They end up having to rely on their family's resources to be able to push these cases through. If you have a true Hague case where you have good solid evidence and you can rely on habitual residents, it's actually a very quick return. You could have that case done in $30,000 or $40,000. It's where you get into contested hearings and trying to apply bailiff, and you end up in someone ordering a viva voce hearing and 7 or 8 days of trial evidence. That's where the big money comes in, and almost always there's an appeal from these cases. Yeah, and we'll get to that later, but most people are having to rely on the good graces of their families to be able to prosecute these cases.
And I think that's probably in the ballpark. If you have a 7-8 day trial, just in a regular family matter, you're going to be into it for a few $100,000, depending if you're bringing expert witnesses in. Let's see what our audience thinks here. Should the new evidence be allowed? Clearly, 67% think yes, 33% say no. That ties in nicely to our next subject matter, appealing decisions. Fareen or Fadwa, you want to take the lead on this one?
Yes, so the rules have strict timelines for the hearing of applications in wrongful removals. But when we're talking about an appeal, you've got the decision that's been rendered, and really the appeal requires counsel to operate at breakneck speed. Arguably, the decision to return a child or assume jurisdiction is final. And while the rules necessarily provide for a 30 days timeline to appeal a final order, we recommend that the notice of appeal be prepared, served and filed within 7 days. Just to err on the side of caution. The other thing that you can do, which was done in our case, is to utilize judicial conference calls with the Court of Appeal. That's recommended in order to set out timelines for the hearing and the submission of materials. These are time-sensitive issues, and so it's important for that to take place. It's obviously important to both parties as well, as someone wishes to have the child remain and someone else wishes to have them returned immediately. Appeals are fact-specific, and Fareen's going to provide some brief comments on how now that the bailiff test is a hybrid one, it may be worthwhile to actually take another kick at the can in light of a recent decision called JF versus KF, which is a decision from Newfoundland where leave to appeal to the Supreme Court of Canada was denied.
Yeah, and that was in 2022. So the citation for that is JF versus KF 2022, Canley 113173. And so the trial judge ordered the return to Boston, and the Court of Appeal overturned it and said that the child would stay in Newfoundland. And like Fadwa said, the appeal to the Supreme Court was denied. But the Court of Appeal and the trial judge set out the law with respect to return orders. With bailiff, like Bryan said, it's the hybrid approach, right? The hybrid approach being, what was the focal point of the child's life prior to the separation? And how does that tie into the parental intention and the habitual residence? So it's not this clean test that it used to be. Bailiff has had, there's, a few more elements in it. We used to say in Hague cases, well, it's not a best interest of the child determination at that stage, because the country that's going to receive, the country where they're habitually resident will make that determination. With bailiff, it's sort of, it's now going to be really fact specific about what's the focal point of the child's life that must be determined. And that is really more of the focus of the analysis. I think it makes sense because you want to be child-centered, child-focused, right? And you really want to focus on that. But there's obviously other tensions that pull against it. The Court of Appeal, and there's two paragraphs that I think are really excellent. One is paragraph 60. I'll take you to the result first. Paragraph 126 of that KF v JF or JF v KF, depending on whether it's the appeal level.
And we'll put that into the show notes for everybody, so they'll get a copy of it after we're done our program, but go ahead.
But it says, in the result, I'm of the view that the focal point of that child's life was St. John's. She's been there for over a year at the time, which was an appreciable period of time for a 7-year-old child. And this is a theme that keeps coming back, right? Which is, how long have they been there? By the time the courts hear it, and both Bryan and Lindsey and I were going to comment on that in terms of our case and other cases since then, Lee and Rubio, of course.
Isn't that kind of rewarding, the delay and the conduct, though, saying, okay, well, they've been here so long, we've got this other case we're going to talk about. It's kind of
unfair.
But
it's the delay of the courts. And so this is where I think the conversation really, let's talk about it a bit. I've got the statistics.
Well, let's circle back to it, because we're going to come back to it, I promise. But let's just wrap this section up with tips and tricks. Bryan has his hand up.
Well, let me
I just wanted to add one thing on the appeal decisions.
Yeah.
And when you're acting for the respondent on the appeal, so you've succeeded at the trial and your friend has appealed, they're probably going to get a stay from the Court of Appeal. They hear those motions and they deal with them very, very quickly. What you need to do as the responding's counsel, you need to get an order to expedite the appeal, and they will give you that order, and you can have your appeal heard probably within 2 months of the actual trial or motions decision. So they move that really, really quickly. You can't control how long they're going to reserve, different issue, but you can get the appeal moved very quickly.
All right, so Hague Convention.
Russell,
Yeah,
I think it's worth sort of adding, just in terms of the time frame, the Hague Convention does a statistical analysis. The central authorities look every 5 years at the statistics. They didn't do it for COVID, but the last statistical analysis was 2015, and the average cases were 129 days. In 2008, 5 years before that, the average cases are 145 days. So they are trying. The trend, this delayed trend that we experienced, that Lee and Rubio experienced, seems to be a more recent trend. When you look at the statistics, that's the intention. That's what the rules are trying to do as well. The intention is they should be heard within 6 months. But KF and JF.
Contextually, right? We're just coming out of COVID too, right? You can only move the cases so quickly when courts are not functioning at full speed. But let's just do some quick tips and tricks on
Sure,
the
but
convention.
The takeaway with KF and JF isn't the time frame. It's about best interests of the child and whether or not that applies. Because statistically, we've said, historically, we said that best interests of the child doesn't apply to convention applications. But this case, which was denied leave, has shifted that somewhat. The Court of Appeal says, yeah, I'm not looking at best interests, but I'm considering a child's general interests when focusing on the focal point of the child's life. So you want to look at paragraph 60. General interests are at the heart of the test for habitual residence. So there has been a bit of a shift about some of this. And so when you're looking at tips and tricks, like Fadwa said, it may be worth another kick at the can, because these factual considerations, this individualized approach is really what they're looking at. And so, bailiffs become unwieldy, and then how you apply it means that it may be worth an appeal sometimes.
All right, Lindsey, tips and tricks, any takeaways on this subject?
I mentioned this on our discussion yesterday, but the applications for Hague and non-Hague matters, I think, are becoming more common. And as Fareen spoke to, the rules are expediting these cases. And the best advice is to establish a rapport with your opposing counsel and cooperate on things like briefs and documents and examinations. You have a punishing timetable for the trial and at the appellate level, and there's simply no time to waste. So that is a resource. You might not agree with them, but there's cooperation required in order to facilitate those timelines. And with that, ensuring that you put the time into your TMC and really, having a judge who takes you through that. We had the benefit of that with Justice Kruzik, and very much helped us. But we did not know who our trial judge was until the Friday before. And as counsel, we advocated for a caucus with the trial judge. We did not know whether it was going to be virtual. We did not know whether it was going to be in person. We did not know if printed briefs were required. We did not know if we had a quick conference call with our judge, answered all those questions, and allowed us to just get that administrative stuff done. So don't underestimate how much time that will take, and plan for it. And I think these cases go really, really fast. That can eat up a lot of your time.
Yeah, really good.
And
Try to have a good relationship with opposing counsel. A great tip. Fadwa, you want to add anything quickly before we send it over to Bryan for his tip?
No, I think I'm okay in terms of those tips.
Okay.
He provided a great summary of the things to do to sort of get that moving.
Any last tips, Bryan, before we move on?
I think the key tip in any Hague case in particular is if you're acting for the applicant, you step on the gas as hard as you can, and then you step on it harder. And then if you're acting for the respondent, a lot of tactics that are often used to delay cases are quite inefficient if you've got a good case management judge. So on the respondent side, you have to really make sure that your evidence is going to be up and ready to go on the habitual residence side, because you're not going to win the case on most harm principles under Hague cases. It's often done under the habitual residence.
Thank you. That was a great summary, everyone, on a very complex issue. So let's do a poll question, get to our audience and see what they're thinking. In Hague cases, is expert evidence required regarding foreign law? A couple questions coming in the chat box as we're going through this. TMC is a trial management conference. Fareen, do you want to explain quickly what a chasing order is?
Sure. It's when you get the order in the country where the left behind parent is. It's where the child isn't there, like the child has already left the coop. But it's in the country where they were habitually resident until the removal happened. And it's in many cases to establish custody in that habitual residence, and custody rights in that jurisdiction.
Is it sort of like putting a lien on a property? You're putting a lien on that particular child, saying, you know what, there's an interest here.
You have to be very careful with chasing orders, because chasing orders can have the opposite effect, especially in Hague applications, where part of the test of the Hague application is the presumption of a return to have an issue decided. So with the chasing order, if the issue is already decided, it complicates Hague Convention matters. The opposite is true in non-Hague matters, where
okay, which we're getting to in one moment. Let's see what our audience is thinking here.
It's also a country like Canada or Ontario saying we will apply jurisdiction here. So it's confirming that the other country will apply jurisdiction.
All right, is expert evidence required? 25% said yes, 13% said no. It looks like all the lawyers are saying it depends. Classic response. All right, so one more quick topic, and then we're going to get into the Supreme Court decision, and everybody's moving along very quickly, and I thank our panelists for being so quick. What are non-Hague cases and how are they different?
So I'm going to sort of try and briefly run you through that, but I think one of the important issues is that you have to confirm that you're not making any presumptions about a non-Hague country. Countries like Burkina Faso, Botswana, Lesotho, Tunisia, Morocco, Iraq, Zambia, Zimbabwe are all signatory states. So you want to make sure that you are, in fact, dealing with a non-signatory state, and that's so that you follow the correct procedure. But that being said, from a theoretical perspective, Canadian provinces treat child abductions from non-signatory states in a manner that's comparable to the Hague Convention. First, they decline to decide parental disputes on the merit with respect to children who are not habitually resident in the province or territory. And then secondly, by favoring the return of the child to the jurisdiction of their habitual residence. But these similarities don't mean that an application brought under provincial legislation is treated the same way as one that's brought under the Hague Convention. So the legislative framework that you're going to refer to is still found under Part 3 of the Children's Law Reform Act. And the first step is therefore to determine whether Ontario has jurisdiction. If it doesn't have jurisdiction, the court must consider if there's an exceptional circumstance that would allow it to assume jurisdiction. The only exception is that of serious harm. So if no serious harm is found, the court can decline jurisdiction and then exercise one of its residual powers for the return of the child to an appropriate place. And I think before I get into the specific provisions under the CLRA, I think it's important to highlight the purpose of Part 3, which is found in Section 19, as it provides necessary context for how to confront the question of best interest and its application to Sections 23 and 40, which I'm going to talk about shortly. Really, there's no question here that the overriding concern is for upholding the best interests of the child. It's enshrined in the CLRA, but Section 19 sets out objectives aimed at discouraging child abductions and ensuring that parenting matters are determined in the jurisdiction where the child has a closer connection. So at the same time, though, Section 19 also sets out that the ultimate determination of a parenting order on the merits will be made on the basis of the best interests of the child. And to account for that fact, particularly when you're dealing with non-signatory states, Ontario courts do not automatically assume, this is really important, that best interests of the child principle will be applied to the merits of the custody dispute in the foreign country. So as part of the jurisdiction consideration, judges assessing applications for the return must consider what Justice Kazurer identifies in the Supreme Court decision, which we're going to get to shortly. He calls it the tenor of foreign law, generally through expert evidence adduced by the parties. So this notion was affirmed by, affirms what Justice Laskin had actually said in the case of Ojikeri, specifically that by becoming a signatory to the Hague Convention, countries agree to follow reciprocal obligations under the convention and warrant that they are firmly convinced in the interest of children as being the paramount consideration. With non-signatory states, we don't have those same assurances. Some may apply best interest, others may not. So how do you start the process? You bring an application in the usual course, and parents that have committed the wrongful removal can ask the court to assume jurisdiction under one of the 4 sections of the Act. Those relevant sections are 22(1)(a), and that's where the child is habitually resident in Ontario. And the CLRA actually defines habitual residence under section 22 sub 2. I would suggest that this section is rarely satisfied, particularly because most children haven't been in Ontario for very long at the commencement of proceedings. Really, where you find it is under section 22(1)(b), which is where the child is not habitually resident. The court looks at 6 separate criteria, all of which must be satisfied. That's really important. And some of which include the presence of the child in the province and connections with the child and their connection to the province itself. Section 23 is the serious harm exception. And that's where the child is present, present in the province, but on a balance of probabilities, the court satisfied that the child would suffer serious harm if they remain or perhaps return to the care of the person entitled to custody. And in order to determine the issue of serious harm, the courts have to assess the likelihood and severity of the anticipated harm, considering all relevant factors. Notably, every province in Canada has some version of the serious harm exception enacted into legislation. And it's worth also noting that the threshold for serious harm in non-Hague states is lower than the grave risk of harm found in the Hague Convention. The last one that I would suggest is section 69, which is the parents' patriarch jurisdiction. That's the court's inherent jurisdiction, and you want to be careful about invoking this section. But I'd recommend pleading it every single time. And so if one of the 4 sections can't be made out, you're moving into section 40. The left behind parent brings their application under section 40 of the Children's Law Reform Act. And the court only has jurisdiction under this section where the child has been wrongfully removed or is being wrongfully retained in Ontario. And the court has determined that they can't maintain the child or doesn't have jurisdiction to determine parenting rather. And so there are 3 remedies under that section, but the Court of Appeal in Galadin and Rauda point out that where the court finds no risk of serious harm and refuses to exercise jurisdiction, a return order under section 40 does not automatically follow. Section 40 lists things that the court may do, and Article 12 of the Hague Convention, by contrast, obliges a court to return. Section 40 doesn't operate in the same manner because unlike the Hague Convention, the court is given broad discretionary powers. And just to add an added layer of contrast, the Hague says that you return the child to their habitual residence. The section 40 says to return a child to an appropriate place. So I think the use of the word appropriate place in the legislation really underscores just how broad the court's discretion is in that section.
Okay, we got our next poll. Question came in. Thank you so much, Fadwa. That was excellent. How do you affect service in a non-Hague country, Fadwa?
Well, what you're normally going to do is do service in the same way that you would normally serve under the rules. You don't have to operate with a central authority or otherwise. You're serving in the exact same manner. So by personal service. The
local rules, I assume, or
yes.
Ontario rules?
Yeah, the provincial rules of Ontario. So you're trying to bring it to their attention in this jurisdiction.
Okay.
Russell, just 1 second. Some of the service stuff is a little misdirected when you think about it, because the person who has taken the child is in Ontario.
Mm-hmm.
So the person who's seeking a return order is serving within Ontario. So we just satisfied our own rules. It's really quite easy. The service out of jurisdiction becomes a problem if they're trying to start a proceeding here and suing the parent who's left behind in the foreign jurisdiction, which isn't usually a real problem. Usually it's getting the proceeding here dealt.
Right. Okay. Great point, Bryan. Thank you. So next poll question, who do you think is more likely to abduct? Men or women? Let's see what our audience thinks. Oh, about 50-50, 44% men, 56% women. A practice tip came in from counsel who's watching. If you're taking one of these cases on, get a retainer, because there's a chance you're not going to get paid if you're not successful, or even if you are successful. But let's move into FVN, recent decision of the Supreme Court of Canada, talking about these issues. we're very fortunate to have the 4 lawyers who argued the case before the Supreme Court with us today. If I understand, it's Fadwa and Fareen for mom, Bryan and Lindsey for dad. You got Fareen or Fadwa, you guys just give us a really quick background introduction, maybe a minute or two.
Yeah,
I'm
absolutely.
sorry, a minute or less, because we're running short on time.
I promise you it's a minute or less. The mother was a Canadian citizen, the father's a Pakistani citizen, and they have 2 infant children who were at the commencement of trial ages 4 and 1. The parties were married in Pakistan, but living in the UAE where the father was on an employment visa. The mother returns to Ontario where her family resides with the consent of the father in June of 2020. She later advises him that she does not intend to return, and then the father commences an application for the return of the children in both Ontario and the UAE.
So what are the top 3 arguments for mom?
So the top 3 arguments are for mom are centered around serious harm. Basically that she has precarious residence status. First, as a divorced non-national woman, she has no independent status to remain in the UAE, and that she would have prejudice faced by the application of UAE law because they don't determine parenting on the basis of best interests, but rather on gender-based assumptions, which prevent women from being guardians or decision makers for their children and provide circumstances in which they would automatically lose their custody or caregiving of their children entirely. And then her precarious status is linked to the separation of the children from their primary caregiver as children, as infants. And then third, the untenable settlement proposal of the father and the fact that there was no evidence to suggest that he could satisfy any of the terms of his proposal, which was made to facilitate her ability to remain. So there was no evidence that he could afford to purchase, for instance, a property in an amount that would be able to grant the mother a residence visa so she could stay in the UAE.
Thank you. I'm going to flip this over to Bryan and Lindsey for the top 3 arguments for dad. But I don't know why the courts are considering settlement proposals in any event. Aren't they confidential? But let's flip it over and hear what dad has to say about this case.
I'll deal with that first, Russell, because bailiff in Canada says you need to look at undertakings that people are going to give to ensure that when the child is returned, if the child is returned, that they'll be adequately respected. So it's not a settlement proposal. It's a proposal to provide assurances that the child will be safe. So
Okay.
People like to call it a settlement proposal. It's not a settlement proposal.
So is their plan moving forward, basically?
Yeah, it's their plan moving forward, and it's also the plan for the taking parent. If the taking parent chooses to return, what are you going to do to ensure that taking parent is protected? So the father's main 3 arguments are obviously just the counter to what Fadwa has set out. And what he does is he marshals a whole series of evidence, layperson and expert, to show that there are no issues that present in the UAE dealing with residential problems for the wife. She can live there. Secondly, there is no gender or other problem in the UAE, and that the court must be very careful to not lump all of the bad boys of the international world into the same basket, and you need to look at this on a country by country basis. Extensive evidence is led about what the UAE is actually like and how its law works. And I think that the most important point that comes out of this in the Supreme Court of Canada case is the powerful argument raised by the wife that if the children are removed from the mother, their primary caregiver, that in and of itself constitutes serious harm. That goes all the way up to the Supreme Court of Canada, and the Supreme Court of Canada says that's not right. Removal of the primary from the primary caregiver is not in itself serious harm. You need to look at all the circumstances. So those are the 3 key points, I think, from the father's perspective in terms of evidence. And then that segues into the appeal. And Lindsey's going to talk about that because this case is really broken into the trial and then the 2 appeals. So I just want her to speak to that.
Yeah,
So Lindsey, what did the court decide?
So which one?
We got enough time to talk about the Supreme Court. So
Okay,
let's talk about that
super
one.
quickly. The Supreme Court of Canada upheld the trial judge's decision and returned the children and ordered to return the children to Dubai. And in this case, the trial judge heard a great deal of evidence in a short period of time and produced comprehensive written reasons on an urgent basis. And that process is required in every one of these cases and where the situations need to be resolved one way or the other quickly. So the trial judge had to rule on the mother's objections to her return, which Fadwa spoke to, which is her securing an independent residency and agreeing that the children would reside primarily with her. But the trial judge's decisions on these points, and he found that those were not valid concerns. And in conducting this serious harm analysis, he made discretionary, individualized, and fact-specific findings, the very essence of his job. And the father argued that the absence of deference to such decisions, then the appeal becomes a second trial, taking more time to the detriment of the system and to families. The majority of the Supreme Court of Canada agreed with the father on its position on this and concluded that the trial judge had already considered and rejected the arguments and his findings were entitled to deference. So the Supreme Court of Canada only in the rarest of cases interferes with findings of mixed fact and law by trial judges, especially when confirmed by the Court of Appeal. So it was surprising that the minority chose to do so here, given the majority reasons and the minority full agreement with the law as stated in the majority reasons. So the SEC is almost always a court of policy and law, not of error. And the challenges on these cases on appeal is, despite courts saying deference applies in these fact-driven matters, there seems to be more of a willingness on the part of appellate courts to retry these cases. So it makes it very difficult to predict the outcome of these cases.
All right, 30 seconds or less. Takeaways on this case, and then we're going to go into one more quick one if we can. Let's start with you, Fareen. 30 seconds or less. Takeaway on the outcome of this case.
I don't think that's fair. The takeaways are the real piece here, right? Like the takeaways are, forget everything else. The takeaways are the takeaways. There's really 3 or 4 different takeaways on this one. Undertakings, appellate deference, gender needs to be commented on, and the trends in the case law. Let me start with undertakings, because that's an interesting one. The undertakings in international parenting disputes, as Bryan said, that was bailiff, which was a Hague case, right? So in non-Hague cases, when you have Hague cases, Canada has reciprocity, there's assurances of best interests, there's warranties, there's an ability to enforce undertakings. So when you're in a non-Hague country, what will these undertakings mean? Do they have any force? Are they binding? How do you make the foreign jurisdiction enforce them? Will they be implemented and applied? If there's a breach of the undertakings in a country where there's no reciprocity, there's no reciprocal agreement to enforce their undertakings, what happens? How do we grapple with the fact that there's no mechanism to enforce the undertakings in these foreign jurisdictions? And what if the undertakings are contrary to the public policy of the foreign nation? Like Fadwa said, guardianship is decision-making, which is automatically allocated to fathers in some countries. What if the undertaking is contrary to that tenet of their country's laws? That's territory for another day, uncharted territory, because we're going to have to see if these undertakings are breached in these non-Hague countries, what will happen? So the SEC didn't comment on it. Justice Kazir says undertakings are a way to provide an answer to an anticipated risk of harm in addressing obstacles. But
if our audience wants us to come back, we can do an advanced topic on this, but there's so much to cover. Bryan, takeaways or thoughts on this one?
I think the main takeaway is that evidence matters. And what's more important within that subtext is that expert evidence matters in non-Hague cases. To go back to your poll, by and large, expert evidence is irrelevant in a Hague case. It's hardly ever put forward. It's absolutely critical in non-Hague cases to prove what the law not only is in the statute, but how it's implemented in non-Hague countries. You win or lose on those.
I think the other just quick point that we need to point out, which wasn't actually said, was the majority and the dissent in the Supreme Court of Canada agree on the applicable law. Where they part company is in fact in the application of the law to the facts before them. So facts are these cases are incredibly fact driven and very fact specific. So the dissent highlights how they would have necessarily overturned the judge's decision and ordered that the children remain in jurisdiction be assumed. So I think that's an important takeaway too, that it's very fact specific, but the law, as the SEC has pointed out, is consistent. Both the dissent and the majority agree on that.
Let's talk about Lee and Rubio real quick. Bryan, what are the facts of this case? What do we need to know?
child in Peru, child brought to Canada, child's here longer than child should be. 2 years later, you end up in appeal. Justice Bonato says, child's been here too long. I'm not going to send the child back, even though, father, you're right, and the child should have gone back right away. Courts took too long, but I'm not going to take that out on the child. It flies directly in the face of all the principles under the Hague cases. The Supreme Court of Canada directed and bailout for speedy hearings, but that's the result. The father wins the appeal and loses the result.
All right, so let's put the rule 37.2 up, Shannon. Let's see what our audience thinks if this decision would be decided differently. Lindsey, I'm going to give you a quick second on a takeaway from FVN because we didn't get to you. Anything you want to add?
That my takeaway, it was all lumped in one.
Okay, so let's see what our audience thinks if this case would be decided differently. 52% said yes, 31% said no. Interesting thing I learned about this rule yesterday. I thought it came out as a result of this case, but Fareen was telling me it was in the works already. So Fareen, 30 seconds or less. You've already talked about this rule. You want to add to it at all?
Nothing to add to the rule.
All right. So thank you.
Russell, in terms of the delay, the trial judge moved at lightning speed in this. The Court of Appeal took 8 months on a reserve, and the Supreme Court of Canada took 8 months on a reserve. So when the Court of Appeal in the Rubio case is chastising the underlying system for delay, and rightly so, no one's watching the Court of Appeal and the Supreme Court of Appeal in 16 more months of delay. There are real institutional problems within our system. And it seems to me that the answer is they can't be in place and undermining the application of an international treaty. There's something wrong with the system.
And Rubio said we would send you back, but the kid's been here too long. Now it's against it, it's terrible, right? It's a complete injustice. So I agree with that.
The council on the screen worked damn hard to get our stuff together. The trial judge gave us his decision in 2 weeks on the eve of Christmas.
I know, but to say,
And then 16
administrative
months
delay, that means you're not, the kid's not, I agree with everybody. And I think you guys have done a fantastic job. Let's get a couple quick audience questions in. We're going to wrap this up for 1 o'clock. Hopefully we're going to invite you all back because it's a fantastic discussion. Like I said, it's a 1 day of material jammed into an hour. So let's see what our audience has to say. Welcome back, Shannon. Thank you.
Hi, thank you to our panel and thank you to all of the audience for participating. I know a lot of the questions have been answered throughout, but just want to maybe get in one more question before we sign off today. So a question that came in from the audience was, should parents and family law professionals, what should parents and family law professionals consider when a parent wishes to travel with the children to a country that is not part of the Hague Convention?
I would say don't send them, but who wants to take this one?
So there's a variety of things that can be done in order to sort of put in safeguards in place when they're sending a child to a country that's not a signatory. There's the implementation of a bond. Basically, it's a payment of money that goes into court to allow the party who is remaining here, for instance, to use those funds and access them to litigate in order to have the child return in the event that the child isn't returned. Basically, the other party that's taking the child forfeits the amount. So it's a financial incentive to have them return the child on time. You can submit passports to authorities or to counsel in jurisdictions when they're there. You can register the children with the Canadian Embassy abroad. Every single embassy abroad, Canadian Embassy abroad, has a registration system for you to be able to register children. If there are issues with the child as well, you can contact Global Affairs that has a dedicated division related to in the event that children may not be returned. So I think all of those sorts of safeguards, promises, if you can get a mirror order or some sort of undertaking in the foreign jurisdiction as well, it's worthwhile to do. But those are all sort of things that would assist in trying to incentivize the parent to return the child in a timely fashion. I find the bond to be the most useful one, particularly if it's a larger sum of money.
Great. Thank you very much, Fadwa. And thank you again to all of our audience members for attending and for your participation today. We also want to extend our gratitude to our guest speakers for sharing their time and knowledge. We really do appreciate it.
Thank you, everybody. That was really insightful and really helpful. And I want to thank our audience for joining us today. We hope to see you again.